possible for an unmarried individual to adopt, and that is equally available to non-heterosexual individuals. Bench has agreed that it is for the legislature to look into this particular issue. It's for the parliament to look into this issue. The government may want to look at what kind of operational issues it can address without going for legislative amendments of the SMA. I understand, based on the pronouncement, that it's a 3-2 judgment in terms of 3 judges of the bench concurring on the one side, which is Justice Bhatt, Justice Narasimha and Justice Hima Kohli. And Justice Sanjay Kishan Kaul has agreed with the position of the Chief Justice of India, Shri D. Chandrachud. Broadly, I think they've all taken the same position on the question of whether the Special Marriage Act can be interfered with and can it be struck down as unconstitutional, whether certain provisions can be struck down as unconstitutional. On that, the bench has agreed that it is for the legislature to look into this particular issue. It's for the parliament to look into this issue. I think there are certain disagreements on the reasoning of 3 judges on the one side and 2 of the judges on the other on the very same issue, but the net outcome on the question is the same. But the larger disagreement appears to be on the issue of adoption. And on that, I think Justice Bhatt, Justice Narasimha and Justice Kohli have categorically held, based on the pronouncement, that this is also for the legislature to look into because there are multiple safeguards to be considered. And Justice Chandrachud and Justice Kaul have taken the view that it's possible for an unmarried individual to adopt, and that is equally available to non-heterosexual individuals. The position, of course, the net result is that because 3 judges have taken one view on both the aspects, that would become the majority view. This is the overall tone and tenor. Plus, I think there are also common observations of the right to unions, civil unions, but the recognition under the law as to whether they can be treated as marriage or not has been left entirely to the legislature. And 2, there are of course directions to prevent any kind of harassment of people on the basis of their sexual orientation or their gender for that matter. And those are the prescriptive safeguards that the bench has come out with. And of course, the assurance of the government has been taken on record that it shall constitute a committee under the stewardship of a cabinet secretary to look into these aspects to see what kind of operational difficulties of non-heterosexual couples can be addressed in terms of, let's say, nominations for ration cards or insurance policies or bank accounts, so on and so forth. So we need to see what exactly are those directions, but ultimately the better part of the judgment has relegated most of these issues to the legislature and the executive.
What do you think? What will happen after this judgment?
See, I think obviously the other side may prefer a review or a reference on certain legal questions. I'm not sure of it though. And 2, I think the government may want to look at what kind of operational issues it can address without going for legislative amendments of the SMA. Because ultimately on the question of legislative amendments to the SMA, because it involves the question of revisiting the institution of marriage, the parliament may want a wider consultation. The in-between measure or the via media could be that it recognizes certain civil unions without giving them the same status as marriage, and also has a different regime if they wish to adopt. And those are aspects where, of course, child health experts will have to be considered. So I think that the government as well as the parliament may perhaps constitute a committee. And of course, I don't know the exact details here. They may want to, they may consider this. That's what I think will happen.